Welcome back, everyone, to the second panel of the symposium. This one will discuss international trade and national sovereignty. Our moderator tonight will be Judge Stephen Alexander Vaden. Judge Vaden serves as a judge on the United States Court of International Trade. Before joining the court in 2020, Judge Vaden served as General Counsel of the United States Department of Agriculture. He also served as a member of the board of the Commodity Credit Corporation, a government corporation devoted to helping American agricultural producers. Judge Vaden has worked for two law firms, Jones Day and Patton Boggs. At both, he served as an appellate litigator and as part of the firm's political law practices. He received his JD from Yale Law School and his BA from Vanderbilt University. Judge Vaden clerked for the Honorable Julius Smith Gibbons on the U.S. Court of Appeals for the Sixth Circuit and the Honorable Samuel H. Mays Jr. on the United States District Court for the Western District of Tennessee. Judge Vaden, thank you for joining us today.
Thank you so much, Eric, and thank you to each and every member of the University of Pennsylvania chapter of the Federalist Society. You guys have done great putting this conference together on a very timely topic about the intersection of international law and American domestic law. Our panel this afternoon is about international trade and sovereignty and how the two collide. A very timely topic indeed. For today's run of show on this panel, we've got four great panelists for you, each of whom will have about 10 minutes to give opening remarks. Following that, we'll have a period of inter-panel discussion where the panelists will be able to make comments about what their fellow panelists have said. And then we turn it over to you who are watching with us this afternoon on Zoom. During our panel, if you have a question, please bring your cursor down to the chat function and type it in at any time. Please be sure to indicate whether the question is for a particular panelist, the panel as a whole, or no one in particular, and anyone can address it. Once the question and answer session comes, I'll be looking over to that panel and we'll pick and choose among the questions as time allows. So let's get started. First, I want to say just a couple of things to set the stage for those of you who may not be trade experts. Trade has been in the news more than any time in recent memory over the past period of years. From the policy implications of trade decisions of the past to the economic effects that those trade decisions are having on everyday Americans in different parts of the country. And there's good reason for this. For years, there was consensus on trade policy, particularly in the United States. Free and unfettered trade of both goods and services was the goal, and it was seen to be an unmitigated good that would lift all boats. However, in recent times, that consensus has begun to break down. And instead, what we are seeing is a new set of questions being asked about whether trade is universally lifting all boats, whether the economic benefits of trade are truly evenly distributed throughout our country, and others are raising concerns about national security and items that we trade with individual countries that may seek to be our rivals, and whether or not we should maintain some type of domestic manufacturing or other capacity on our own here in the United States. This questioning of what had been a broad-based consensus of trade policy has been coupled with a rediscovery of statutes governing trade policy that have lain dormant for the past 30 years until recently. Two of these statutes have been much in the news. Section 301 of the 1974 Trade Act allows for the president to place tariffs on items coming in from countries who engage in unfair trade practices. A common example is the alleged theft of intellectual property, led the Trump administration to place tariffs on certain goods from China using Section 301. There's also Section 232 of the Trade Expansion Act, which allows for the president, following receipt of a report from the Department of Commerce, to place tariffs on goods from countries that may have national security implications for the United States, were they allowed to be imported into the country without any such limits. And the rediscovery of these statutes has also brought along a remembering of the fact that although Article 1, Section 8 of the Constitution expressly grants to Congress the power to regulate commerce with foreign nations, Congress has largely delegated the actual decision-making function to the executive branch through the passage of statutes that make that delegation very broad and subject only to the most general of standards. Since we're all lawyers or people who want to be lawyers primarily on this call, you've probably already guessed that the change in norms that appears to be happening, coupled with the rediscovery of old statutes that happen to grant the executive branch a lot of wiggle room to make decisions, can lead to only one thing, and that's litigation. And that certainly has been true over the past couple of years. A record number of suits have found their way challenging executive branch decisions on trade policy to my court, the Court of International Trade. The Court of International Trade is a specialized court, an Article 3 court, so our judges have life tenure. We have nationwide jurisdiction over all matters impacting international trade. And although the courthouse is in New York City, we, unique among the federal courts, are kind of a vagabond. We have the ability under the law to set and hear cases in any port of entry in the United States, or, if needed, internationally. Last year, 3,948 cases were filed in our court, a record. To put that number in perspective, the prior year, 2019, saw only 219 total cases be filed in our court. And even if you were to subtract from that 3,948 cases that were filed in the Court of International Trade in 2020, the 3,500 or so cases that are dealing with Section 301 trade tariffs that were put in, you still have a remainder of 388 cases on other trade topics, which in and of itself represents a 50% increase from the prior year's total, which, as I mentioned, was 219. So these trade policy decisions are now very much front of mind in the law, and the federal courts are working their way through some of the questions we'll be talking about today. But our topic today is trade and national sovereignty. And before you can make any of the nitty-gritty decisions that I've just broadly covered here in just the past few minutes, you have to make normative judgments that are going to guide your policy instincts. Whether, with whom, and under what conditions to trade are all sovereign decisions that are made by sovereign governments. And because they are frequently the subject of negotiation between those governments when they are trying to reach a trade agreement, you have the interesting prospect that certain elements of national sovereignty may be negotiated away, in some people's point of view, from one party to another. That, of course, is going to lead to both political and legal disagreements. And that's what our panel is going to address today. So without any further ado, let me introduce our first of four panelists who will lead things off. Our first speaker is Mr. Gary Horlick. Gary has represented leading U.S. and global companies in international trade negotiations and disputes, and he has chaired the World Trade Organization and Mercosur, that's a South American trade group, dispute panels. He has served as International Trade Counsel for the Senate Finance Committee. He's headed the Import Administration of the U.S. Department of Commerce, where he was responsible for all U.S. anti-dumping and countervailing duty cases. All of the decisions he made get appealed up to our court, so he's a frequent litigant before us and a good guy all around. He's also been involved with foreign trade zones and statutory import programs while he was at the Commerce Department. He currently is an adjunct professor at my alma mater, Yale Law School. And he has also taught at the Georgetown Law School and the University of Bern's World Trade Institute. Mr. Horlick graduated from Dartmouth College, and he also holds degrees from Cambridge University and the Yale Law School. He served as the first chairman of the World Trade Organization's permanent group of experts on subsidies. So without further ado, Gary, the floor is yours.
Here we go. Thank you very much, Your Honor. I apologize for creating part of your workload, but it's always a pleasure litigating at the U.S. Court of International Trade. The U.S., one of the major functions of U.S. trade policy is having a neutral, independent court system, and it's a blessing. I'm going to briefly introduce the concept of nation-state sovereignty and then explore its meaning for international trade with particular emphasis on the U.S. approach to it. Discussions of nation-state sovereignty conventionally start with the treaties of Westphalia in 1648 and with its predecessor, the Treaty of Augsburg of 1555. It's worth noting the most important point being discussed in those treaties, and millions of people died in between, was who chooses the country's religion. And this sounds like an alien concept in the United States of America with the First Amendment, but so the Treaty of Augsburg was an international agreement allowing the independent sovereigns of each of the countries signing to choose to be either Lutheran or Catholic. And if you weren't one of those, you were out of luck. A few years later, the Dutch rebel against the Spanish crown because they were Calvinist, and it goes on and on from there. The Treaty of Westphalia itself actually liberalized that. It allowed the sovereigns, typically kings or queens, the exception of the Dutch Republic, which by then was in existence, to choose between Lutheran, Catholic, or Calvinist. This left out a lot of Protestant sects. And where did they go? They went to the newly founded colony of Pennsylvania. And 60 years later, they could go to the first truly secular university in the world, the University of Pennsylvania. So congratulations to you all. You have to look at not only what was in the agreements. So as I already told you, the agreements actually limited the nation state's sovereignty. They could only choose between first two and then three flavors of religion. So they were accepting a limitation on sovereignty in these treaties. Secondly, it, for the first time and the last time for several hundred years, guaranteed an internationally recognized human right. In Augsburg, the people who were not Protestant, Lutheran or Catholic were guaranteed the right to get out of town. And as I told you, some of their descendants came here. This was continued in the Treaty of Westphalia. So you have an internationally guaranteed right. Westphalia increased that, and this will sound familiar to Americans, although quite restrictive, to the ability of the subjects of these sovereigns to practice whatever religion they chose, and I think they meant only Christian religions, in the privacy of their own homes and occasionally in certain circumstances in public. You now see a renewal of interest in internationally guaranteed human rights. It's right there in Westphalia, which surprised me when I looked it up. The other thing it guaranteed was the inviolability of national borders. So in practice, did sovereigns respect those two things? Heck no. And Russia invaded Ukraine as recently as 2014. So you have to look at all this with some nuance. But the concept of nation-state sovereignty was and remains fully operative since then. But as I said, you have to look at it carefully. And Ron may well have some comments on that. In the trade sphere, what that meant was, from day one, and going back to Hittites and Egyptians, sovereign countries chose to make trade agreements because they wanted the benefits of trade. It's that simple. This was a choice. This is a sovereign choice. They didn't have to sign these agreements. The Hittites and the Egyptians were quite separated. I think they only had one possible battle, and that's sometimes considered mythical. But they chose to enter into agreements. And this continues pretty much all the way until now. The only sovereign country of which I am aware, which has no trade agreements, is North Korea. Why? Because every other country sees benefits in trade. The oldest agreement still in effect, I believe, is the Anglo-Portuguese Agreement of 1373, renewed by the Treaty of Methuen in 1707. If that sounds antique, it explains why the British drink port. There was a trade preference. So in terms of public international law, then, to summarize, one of the indicators of nation-state sovereignty is the ability to sign agreements. The state of Virginia, Commonwealth of Virginia, cannot sign an international trade agreement under our Constitution or an international law. There are lots of, in practice, every state has millions of arrangements with other countries, et cetera, but really hardcore binding agreements is for the United States of America, not its component entities. So it's really, these trade agreements are actually one indicator that you're a sovereign country. It's not the only one. A few non-nation states, Hong Kong, although we'll see, Hong Kong, and Taiwan, which is a nation state, and the European Union, which is something, all are signatories to trade agreements. So it's not an exclusive indicator, but it's a good one. So how is this reflected in US trade law and policy? Start off with, and I will limit myself to this bit of economics so I don't embarrass myself. If a sovereign country, let's say the US, chooses to impose tariffs, it can. That's actually one of the aspects of sovereignty. You control your territory and your tariffs. And as Judge Vaden pointed out, it should be up to Congress, what it was historically. But Congress has delegated a lot of that power, which is now a matter of some controversy. That said, so the US, if it wants to, Congress, if it wanted to, and for most of our history, Congress chose to either do this or not, could impose tariffs. If no one else imposed counter tariffs, that was just peachy for us in general. But if everyone else imposed tariffs and retaliation, all of us were worse off. And that's game theory. So a lot of trade policy is really game theory. If I do this, how will others react? And that's general. You can identify exceptions to those rules, but in general, that's what works. So that explains why you have first the General Agreement on Tariffs and Trade in 1947, and then its successor, the WTO. The experience of the 1930s, which countries imposing tariffs against each other willy-nilly, was sufficiently bad that countries got together, and in this case it meant the US and UK, essentially, and decided that that was a bad idea, that we should agree we will reach sovereign nation states, which was certainly the US and UK, were willing to agree not to raise tariffs without some sort of negotiation, et cetera. So that's the core, that's really what GATT and WTO are, is you can't raise your tariffs without some sort of arrangement, some sort of agreement. And that's to cut off the negative sum game theory if everyone went off on their own. It doesn't mean you have to do that. North Korea has chosen not to, but most countries have, and that's why they joined. I'm not telling you you have to believe this is a good idea. I'm just being empirical, which is the American tradition after all. So the US also then chose to enter into bilateral agreements, first with Israel, and then with Canada, and then Canada and Mexico, which was NAFTA, recently USMCA, and now we have somewhat close to 20. Other countries have done more of this. The European Union, for example, visibly has a strategy of entering into trade agreements with every country with which we have a trade agreement, plus others. And in game theory terms, it means US producers, workers, and companies producing in the US have less market access overseas than the EU, Japan, for example. So that's a challenge for any administration is what do you do about that? It doesn't mean you have to do something. You're sovereign, but you may lose out. Your workers may lose out. So we will see what the new administration does, but that's the essential challenge the US faces, is not do you sign trade agreements, but if you don't, what happens when others do? I repeat, it's what others do that matters. The US, the second piece of it from the US was a decision by the US in the 1980s. Clayton Yeutter was the USTR, and then Carla Hills, to seek binding dispute resolution internationally in trade agreements. Why? Well, you can take any number of theories. Start with the fact that Clayton had a great, wonderful person and a great USTR, had a background in agriculture, and as deputy USTR in the 70s, he brought cases against the EU and GATT, but under the GATT rules, the EU didn't have to comply. Legally, they didn't have to comply. It sounds weird in retrospect. So he wanted a binding dispute resolution mechanism, which the US has used very successfully since in WTO for access for our farmers and ranchers, to which I say yay, because I'm the counsel for America's cattle ranchers. And so, but this was a decision, and I remember I was part of a very informal advisory group, not violating the Federal Advisory Committee Act, I hasten to add. And we went to Clayton with this, and he said, and we said, you realize we're going to lose some? And he said, yep, that's okay, because we'll win more than we lose, and that's what's happened. So where we stand right now, as Judge Vaden said, this is incredibly controversial, but some things don't change. Game theory doesn't change. You can complain about it all you want, but if you don't participate in this, you will be worse off than others. And we don't like being worse off than others. So does that infringe our sovereignty? No, it affirms our sovereignty in legal terms, I would hold, and lots of other people do, because choosing to sign an agreement is an aspect of sovereignty. I'll finish there.
Thank you, Gary. You've given us a lot to chew on, and I particularly, from my prior position, like your agriculture references. As Gary knows, and as I'll share to our people who aren't as familiar in trade, agriculture is the one area that the United States has consistently won overwhelmingly in international trade. We have basically an unbroken period of 60 years of trade surpluses when it comes to the United States and our agricultural exports. So like the mention of Clayton Yeutter there's a name that's well known around USDA.
Yeah.
Next up, our second speaker will be Dean Ronald Cass. Dean Cass served as Dean of the Boston University Law School for 14 years. He has also served, particularly relevant to our panel today, as Commissioner and Vice Chairman of the U.S. International Trade Commission under Presidents Ronald Reagan and George H.W. Bush. He is the past chairman of the Federalist Society's International and National Security Law Practice Group. He has received 7 presidential appointments from 5 presidents, spanning from President Ronald Reagan to President Donald Trump. But most importantly, he is the father of a member of the board of the Federalist Society here at UPenn Law School. And so he wants to give a shout out to his son, who undoubtedly has helped them put on this fine program we have today. So without any further ado, to yet another person who once sent work to my court there at the International Trade Commission, Dean Cass, the floor is yours.
Thank you very much. I just want to make clear that it's my daughter who is the boss in the Federalist Society here. So I do what she says when I'm not doing what my wife says. I want to start out with a brief reference to Dr. Henry Kissinger, who is a famous American, very well-known former advisor to presidents and Secretary of State. And Henry Kissinger is also well known for his very deep voice and famous heavy accent as well. Less well known is Henry's brother, Walter, who's a year younger than Henry. And one of Walter's friends pulled him aside at one point and said, Walter, I just have to ask you, you and Henry both came to America from Germany as teenagers, and you speak like everybody else in America speaks, while to this day, Henry retains his very deep and pronounced German accent. Can you explain why that is? Walter looked him in the eye and said, Henry actually does not speak with a German accent. That's simply the way you speak English if you never listened to anyone. Now, Henry may be criticized for not listening to anyone. There is a lot about international trade and sovereignty, which is pretty simple if you simply listen to others. I think it was the great American philosopher, Yogi Berra, who said that you can see a lot just by looking. Trade and sovereignty are much the same. I'll start with Gary Horlick's comments about sovereignty. He certainly is correct that sovereignty consists in the right and the power to do things. It isn't a matter of the choices you make, although those choices may affect the quality of the nation and its ability to exercise sovereignty in the future. But certainly, whether you choose to have closed trade or open trade is equally an exercise of sovereign authority. Whether you choose to have an economy which is controlled by the government or is relatively laissez-faire, where individuals can do pretty much what they want, either is an exercise of sovereign authority. Trade in itself is not at odds with the notion of an exercise of sovereignty. Trade is something that nations can adopt different approaches to. They can have different policies on, but each policy, whether it's an internationalist policy or it's a more isolationist policy, is a policy that exercises the nation's sovereignty. But the way those policies play out can have implications for the sovereign power enjoyed by a nation down the road. I don't like disagreeing with judges, particularly when they have a modicum of control over me. I will just, however, quibble with one thing that Judge Vaden said. He spoke of the consensus about free trade and the very strong agreement on that. And he certainly is right that that has been the direction of trade policy over a very long period of time after World War II. And there has been a very strong political and economic support for that, and there has been a lot of academic support for that, but it has remained an area of contention throughout this time and throughout U.S. history. When I became a member of the U.S. International Trade Commission, there were people who were already in the trade community who warned me that international trade really was something that very few people liked. And I think the comment that he made at the time was that Republicans didn't like international trade because it was international, and Democrats didn't like it because it was trade. From the very start of the United States, we've recognized international trade as both important and something that divides different people politically. The very first substantive law passed by the first Congress was an international trade bill that placed tariffs on a variety of items. The southern states wanted tariffs on agricultural goods, but not on finished products. The northern states wanted tariffs on finished products, but not agricultural goods. And they did things the way we've always done. They compromised by putting tariffs on both. But we have over time had a an up and down relationship with tariffs. From about 1820 to 1900, US tariffs were relatively high compared to most of the world. After that, the tariffs came down substantially until 1930, when the Smoot-Hawley tariff raised the tariffs back up. And in a period of 2 years, the GDP of the United States dropped by about half. When other countries placed reciprocal tariffs on our exports to them, it turned out that unless you can get agreement to open trade in a way that has opponents as well as advocates in each country, you cut yourself off from access to a wide variety of more complex, more readily available, more varied goods at better prices with better choices than if you open up your economy to trade. So the US generally has followed a relatively open trade policy since that time. It also has changed the way we do treaties with other countries on trade issues. Starting in 1934, with the trade law of that year, what we did, the Reciprocal Trade Act of 1934, we treated trade as a matter of legislation rather than a matter of treaties, meaning you could pass trade laws by a simple majority in each house rather than by a 2/3 vote of the Senate. As a result, we've had an easier time passing laws, but increasingly over time, we have maxed out on areas for which we have had a strong consensus. We have several areas in which we have some restrictions on trade that we have thought beneficial to us. And let me just highlight national security as a particular concern. There are economists who will say that national security is advanced by open trade because you get more access to cheaper products that you can use for everything you need them for planes and ships and tanks. And you also can have a stronger economy, and ultimately a stronger economy is very helpful to national security. At the same time, there are items that are important to our economy and important to national security that we don't want to allow to be monopolized by nations that we may find ourselves at odds with, that we may find ourselves adversaries of. And it doesn't have to be a hot war adversary, a Cold War adversary will do. There are a lot of concerns right now about China on that front. There were concerns back in the 1980s that we would lose out in an economic competition to other countries. Those fears have diminished, but fears about our adversaries who target the strategic use of products that they are dominant in and use those dominant positions to disadvantage the US. Those fears have grown, and you can see in the Trump administration's trade policy a lot of reaction to that, and particularly reaction with respect to China. There also are concerns about cases where products may be used that are sold into the US, but that may have embedded in them attributes that are detrimental to US national security. You see that in concerns about Huawei, you see that in concerns about communications and computing devices, and what sort of traps may be embedded in there, what sort of risks may be in there as well. Recognition that there are national security concerns about trade underlies some of the provisions that Judge Vaden mentioned, including Section 232 of the Trade Expansion Act of 1962. We should take those concerns seriously, but we should also recognize that there is what's known in colloquial circles as a thermos problem. And that is that you may have claims that things are risky to national security. Those claims may be accurate, they may be inaccurate. It's like the thermos which keeps hot liquids hot and cold liquids cold. The philosophical question is, how does it know which to do? When you're talking about claims of national security risk trade, there always is a question about whether we are responding to a real risk or merely one that is argued on that basis by people who have other reasons to make that argument. And with that, I think my time is expired, and I will turn back the floor to Judge Vaden while I am not expired myself.
Thank you, Dean Cass. Our third panelist to speak comes to us from the Northwestern University Law School, and that is Professor Jide Nazible. Professor Nazible is the Benjamin Mazur Summer Research Professor at Law at Northwestern's Pritzker School of Law. He's also affiliated faculty with the Ford Motor Company Center for Global Citizenship. Professor Nazible earned his undergraduate degree from St. John's College. He has an MPA in International Relations from Princeton, and like a couple of other of us involved on the panel, he also graduated from Yale Law School. He clerked for Judge Stephen F. Williams of the United States Court of Appeals for the D.C. Circuit, and before arriving at Northwestern, he has served as a law professor at Chicago, NYU, and Harvard. So he has made the rounds of some of America's finest law schools, and I can't wait to hear what he has to say on the topic of how sovereignty and the publicity surrounding trade policy have gotten us to where we are today. Without further ado, Professor, the floor is yours.
Thank you, Judge. Thank you very much for the introduction, and I want to thank my fellow panelists. I actually, I'm going to talk a little bit about transparency and publicity, and how transparency and publicity often makes, if you want to call it, trade policy difficult. Now, this seems ironic because a common mantra in a certain kind of realm of trade policy, usually one that is libertarian in nature, would suggest that trade policy, that the pathologies of trade policy have to do with the fact that interest groups capture the trade policy making process at the expense of consumers. And if only the consumers could see what was going on, much of this, and could understand what was going on, much of the problems that we have with trade policy, especially the role of protectionist groups, will be mitigated and life will be much easier. And what I'm trying to suggest is actually that's not true in American history. When interest groups are the primary drivers of trade policy, it has often been stable. It's transactional, but usually stable. And when there has been a lot of publicity and transparency in trade policy, it's often been a little bit more volatile. And the reason behind that, I suggest, is that when trade policy is salient, it's usually identity politics. It ceases just to be about economics and a little bit more about identity. Now, when I say this, some people may say, hold on, Professor, how could that be the case? I mean, isn't the reason why it's political because it has distributional effects and some groups win and someone, isn't that why people fight all the time? And I say that may be part of the story, but let's do a counterfactual. Think about tax treaties, for example. If you look at tax treaties and you study the literature on tax treaties in public finance, and by the way, in the law, you discover that a lot of people talk about tax treaties having distribution effects, that some people win, some people lose. And they try to point out the people who win with respect to tax treaties and the people who lose. But here's a peculiar thing about tax treaties. There's never been a president in the United States who's campaigned and said, the first day in office, the first thing I'm going to do is get out of the tax treaty between us and Peru or something like that. Rarely ever are tax treaties salient. Trade treaties are. And trade treaties are salient in ways that are very interesting because usually, sometimes when they ask you what the economic effects of the trade treaties are and how it affects people, sometimes it doesn't fit with the boundaries of why it's salient. And what I'm trying to suggest is that trade has often performed a role in American life that certain peculiar things have served. Maybe you could talk about slavery, maybe you could talk about abortion, maybe you could talk about a lot of other things that serve as boundary markers. It tells the public, I know which side you're on in American life if you're pro-NAFTA, anti-NAFTA. And because of this sorting potential that allows you to know which side somebody's on, trade is often more salient than I would say the economic issues warrant. Now, just before I go into deep, I wanted to bring two examples of two different people who played a significant role in trade politics and exhibit the dynamics I suggest. In the 19th century, late 19th century, let's say from the 1880s through 1930s, trade was very visible. It was very salient. It was debated. You had mayors, governors, sometimes who would announce their position on the tariff. Like if you're running for governor of Ohio in the 1890s, sometimes you announce your position on the tariff and people would debate it. It wasn't hidden. It wasn't just about interest groups. It was very visible. But one of the things it did is that it drew a clear marker and boundary between what people considered to be what it meant to be a Northern Republican, which usually meant high tariffs, versus a Southern Democrat, which usually meant low tariffs. And that boundary marker sometimes served even beyond, let's say, the economic merits of warrant. Let me pick two people who played a key role. You are, if you are hosting this Federalist Society event, and Professor Jacques deLisle, who's over at Penn, may not know, or maybe you do know, of your colleagues and fellow students over at the Wharton School. The founder of the Wharton School is the name of somebody called Joseph Wharton. In 1881, he gave $100,000 to the University of Pennsylvania to find what is ostensibly the first business school in the world. And what did he ask that school to do? He said he wanted them to teach the virtues of protectionism. Now, whether or not Wharton has kept up its end of the deal, I see a lot of free traders on that faculty, so it's not clear that they're doing everything Joseph Wharton wanted them to do. But one of the things that is not out of the ordinary is that Joseph Wharton was he was the key largest shareholder in Bethlehem still at the time. He was very active in Republican politics. And I think his motives may have gone just beyond purely protecting his economic interests. He really, really did believe that being a protectionist was what it meant to be right, what it meant to be a true American, and what a true Republican would believe in, right? And you would say, how did it get, like he gave this donation in 1881, how did we get to a position where this boundary was so clear? And what I would suggest to you is that if you look at voting patterns from a certain period, let's say around 1887 to 1930s, the voting patterns are just markedly shocking. Overwhelmingly, Republicans voted for high tariffs whenever tariff policy came up. When I say overwhelmingly, I'm talking 80 to 90%, right? Defections from the Republican Party to vote for low tariffs were very, very uncommon. And Democrats voted overwhelmingly for low tariffs. And a lot of them were from the South. But the economics does not explain all of it, because a lot of Democrats who were voting for low tariffs would have benefited from high tariffs. And a lot of Republicans who were voting for high tariffs would have benefited from low tariffs. But the idea that a Republican Northerner ought to vote for high tariffs was so much the identity of that party, of the Republican Party in the late 19th century, that if you defected, it was like you were defecting from the gospel of the party. That was how strong it was. Now you may say, when did this come about? It didn't come about immediately after the Civil War, because after the Civil War, there was some consideration by both parties that the American, if you want to call it, surplus was so high and that was because of our tariff policies, because we didn't have the tax code then, and that maybe there needed to be a bipartisan understanding that there needed to be some kind of adjustment to the tariffs. So Chester Arthur, who's a Republican, a lot of people don't remember Chester Arthur, did propose extensive tariff reform. He wanted to cut the tariffs by 20-something%. He was a Republican. So when did this division happen? People may be shocked to know this, but it started around 1887, 1888. And it had to do with what we call the Mills Bill, which was proposed by a congressman from Texas called Rogers Mill, who was a former Confederate. And he was a Confederate military officer. And what happened is President Cleveland had encouraged him to introduce the bill. He introduced the bill, and the hope was, because the Democrats were in the House of Representatives, that he would introduce the bill that was modest enough that it would pass the Senate, right, where the Republicans were in power. So he wasn't going to do something clearly radical. So what he did is that he took the average tariffs, which were 47%, cut it down 7 percentage points to 40. Now you have to see what I'm saying, 47 to 40. He introduced the bill. And what happened afterwards is one of the most peculiar times in American history because it instigated the longest single legislative debate in American history up until that date. The parties involved with this, including Rogers Mill, didn't anticipate it. But what had happened was that when he introduced the bill, the Republicans observed that a lot of Northern Democrats who normally would vote for high tariffs had defected and were voting for low tariffs. And what did they take that to mean? They took that to mean that Roger Mills and the Southern Democrats had taken over the Democratic Party. That's sort of the ideal of what this meant. Because otherwise, why were Northern Democrats voting for low tariffs? So you get this idea that the tariff is a boundary mark. That if you're a person of low tariff, then you're a Southern agriculturalist. If you're a person of high tariffs, you're a Northern industrialist. This image, this identity, this partisan identity became the defining feature of both of the parties pretty much up until the 1930s. What I'm trying to suggest is that it transcended just the mere economic things, because a lot of economic historians have looked at this and just that in many areas where Northern Republicans were dominant, they could have benefited from low tariffs. And in places like Birmingham, right, and in Louisiana, right, they would have benefited from high tariffs. But somehow the Democrats managed, right, to have this identity, which was sort of what I would call a Southern identity. Now, how does that play up in the modern era? And I know that I have a couple minutes left, but I want to suggest that something like that may be replicating itself in the modern era, which is that where you stand on issues like NAFTA and whatnot can sometimes perform the role of a boundary mark. So if you are pro-NAFTA back in the day before NAFTA was changed or something like that, maybe you're from an urban area, maybe you're sophisticated, you're urbanite, whatnot. The idea that this is the urban conglomerate, you're the type that is pro-NAFTA. And if you're anti-NAFTA, maybe you came from the exurbs, the rural areas, something like that. A signification of like who you are. And sometimes that identity, this is who I am, matters more than the economics of it. Now, this is not unique to the United States. I just wanted to say one thing before we go. If you go to India today, for example, there are a lot of disputes over export subsidies on right, leather. Now, you may think, well, we can have disputes about export subsidies on leather no matter where we are, right? Maybe there are environmental issues. Maybe there are economic issues about the implications of export subsidies and controls. But in India, the politics of it is much more salient and it's much more divisive than ordinary economics will predict. And to understand that, you have to understand that India is one of the largest exporters of leather in the world. And almost everybody who exports in the leather industry is Muslim. And the Indian government is not. And this aspect of this policy can sometimes create, because it becomes a boundary marker. When you're in the Indian government and you're dealing with leather issues and leather export controls and leather export subsidies, a lot of times the Muslim groups that run the leather industry feel that this is a way to hit back at them. And it's hitting back at them not because of just economics, it's because they stand on the opposite side of an identity spectrum. And the problem in the United States is this is now becoming more and more so. And this creates a level of intensity that you often see about trade policy that in my view, sometimes exceeds the economic implications that we would ordinarily expect. And one problem, though, is this, that the more you increase transparency, the more you increase publicity, and the more people care about trade, it's more likely that they're caring more about their identity than they've said, I'm getting really wired up because of trade, because when I look at the rules of origin, it says that 15% of a product have to come from China. No better, very few people get wired up for that reason. Or because they look and they say they're countervailing duties that not have imposed on someone. They get wired up because it defines who they are. And so one of the things that is interesting about trade policy is that if you want it to be effective, stable, and less salient and less unstable, it works most when it's boring and technical. And that's the irony. So boring and technical that the people around this conference may care about it, but not many more people. When more people start to care, the people sitting around this conference table, Judge Vaden, if people care too much, you ought to be worried, because it really means that it's no longer just a legal technical issue, that it's now become much more of a salient, divisive, and identity issue. And I'll leave it at that, especially, by the way, when we find that a lot of people, including those who are well-intentioned, suggest that the solution to a lot of trade treaties, a lot of trade disputes, is to increase the level of transparency so that Americans and everybody can become much more aware. I would say if they're aware and they do care, it probably has ceased to be just an economic issue for them and has ceased and probably been more of an identity issue. And the thing with identity politics is that people just want to win on every time it comes to their time period, whenever they're in office. And that winning means a signal, which means throw the tariff, throw the trade policy my way, throw something my way because I want to reverse what the other side got. No matter how much, I need to reverse it. And that means you have more trade policy volatility, which is what happened from the mid-19th century, late 19th century to the early, which is you could predict anytime a Democrat came into power, the tariffs were going to go down. Anytime the Republicans came in, it was going to go up. It had to go up because the Republicans felt that that was the identity. It had to go down because the Democrats thought that, well, that was their identity. And that was horrible for anybody who was trying to plan for economic reasons, whether you're a protectionist or an export group. It was difficult to plan because you knew when the next party came into power, trade policy was going to head the opposite direction. So I'll leave it at that. And I think I've used up my time.
Well, Professor, thank you. That was outstanding. Everything from a history of the Wharton Business School to identity politics. You have given us much to feast on, and I look forward to the question and answer session to delving into some of the insights that you had. But before we get to that, we've got one more speaker who's chomping at the bit to go forward, and that's the University of Pennsylvania's own Jacques deLisle. Professor deLisle is currently the Stephen A. Cozen Professor of Law and a Professor of Political Science at the University of Pennsylvania, where he also serves as the director of its Center for East Asian Studies. Professor deLisle's research and teaching focus on contemporary Chinese law and politics, for everything from political change and economic reform in China to China's engagement with the international legal order. So you can see why he might have an interest in trade policy. Professor deLisle graduated from Princeton for his undergraduate degree. He went to Harvard for law school and also attended the Harvard Graduate School of Arts and Sciences for some additional study. Professor deLisle clerked for then Judge Stephen Breyer on the United States Court of Appeals for the First Circuit, and he was an attorney advisor in the Office of Legal Counsel of the United States Department of Justice, one of the most important legal jobs anyone can have, as it's OLC, which has the power to issue, short of court opinions, but legal decisions on questions of law that bind the entire executive branch when they issue a formal written opinion. So, Professor deLisle, the floor is yours.
Thank you, Judge Vaden, and it's a series of tough acts to follow, but I'll try to do it anyway. Turning to the China question, obviously any discussion of U.S. trade policy these days and U.S. trade law must engage China. It's the single most fraught bilateral relationship out there in many ways, including in the economic and trade side. So trade and sovereignty have long been a theme and sometimes a highly heated issue in U.S.-China relations, including in trade. And here I don't want to dispute the points that my predecessors on the panel have made, of course, the ability to enter into a trade treaty and bind oneself as a state is an attribute of sovereignty, it's an empowering thing, or that pro and anti-trade moves, sort of liberalizing or protectionist moves, are equally sovereign acts. But what I do want to stress in the US-China context is there are consequences of opting into a liberal regime. They put a lot of pressure to harmonize with and to import the laws that are out there in the international system and perhaps shaped by other countries, certainly the way China viewed it. And where you've got institutions that have some rulemaking and lawmaking through adjudication capacity, as for example the WTO does, you're signing something of a blank check for how your powers are going to be exercised, or at the very least it becomes extremely costly potentially to opt out of the system or to not play by those rules. And that way of looking at things I think is baked into the US-China discourse in this area. And in more detailed ways that I'll discuss as I get further into my remarks, in the politics of US-China trade relations, arguments about sovereignty are very much part of the mix in several ways. So I want to do a story in two acts, as it were. In the first act, the old story, is the era when the US adopted a policy of constructive engagement. And when China adopted, that was the US policy toward China, and when China adopted a policy of reform and opening to the outside world. That basically takes us from the late 1970s on, and especially from the late 1990s on until some fairly recent period, several years ago. We could argue about the exact date. Like most turning points, it's not quite that crisp. But in the old story, the basic economic argument was that China would pursue specialization according to the international economic laws of comparative advantage. China would follow the East Asian model of development. It would produce relatively low-end exports for world markets, and it would gradually climb, it would hope, the value chain to higher value-added, more remunerative production. For it to happen, especially given China coming out of a period of socialist planning, it required that China gain access to the big markets in the more developed countries, including the US. And that required access on most favored nation or normal trading relations statuses. And it required that China welcome foreign investment into China to create the basis for the export industries. Over time, the idea was that the US producers could not only set up for export in China, but could essentially sell to the Chinese market, either by exporting to an increasingly open and more affluent Chinese market, or by setting up production for the Chinese market in the host country. All of this in turn this economic strategy depended on China adopting domestic laws that would conform to international, largely market capitalist standards. Rules that foreign traders, and especially foreign investors, would find sufficiently reassuring, sufficiently protective of contract and property rights, guarantees against expropriation, some degree of transparency of laws, some form of dispute resolution that was reasonably reliable, usually arbitration, and things of that ilk. And it was also an expectation that China would adopt rules that were not only relatively consistent with market norms, but also that were relatively familiar, often in a more detailed ways, to foreign parties. That is, it wasn't just were these good enough, but were they going to reduce the transaction costs? You just transfer what you were doing elsewhere to dealing with China. And in this period, China rewrote a lot of its laws, and it took a lot of foreign advice, sometimes practically off-the-shelf ideas, sometimes some adaptation, but it was a big period of legal transplant and legal import. So China was exercising its sovereignty, but in a way that had it come into line with foreign models. Chinese policymakers consciously sought linkages or spillover effects. The idea is these laws that were adopted for the trade sector and the investment to support trade sector were supposed to spread into the domestic economy, putting firms in China into market competition with foreigners as exporters or as local actors, and that this would in turn lead to harmonization of law. What was initially a kind of enclave law for foreign trade and investment would spread to the broader economy. So the foreign economic contract law became the model for the general contract law sometime later. You see the same things happening in property. You see the same things happening in legal structures for enterprise-like vehicles. Foreign ideas make it in the enclave and then go more broadly. In this long 40-year sweep, China's entry into the WTO in 2000 was the big punctuating moment, but it's a dramatic moment in a longer, slower emerging story. The WTO, of course, requires quite a lot. in terms of domestic law. It requires transparent regulation, of course. It requires national treatment of foreign actors. And it requires intellectual property rights protections through TRIPS. A whole bunch of legal changes. And China did a lot. There was a massive overhaul of trade-related laws broadly defined in the run-up to the 2000 entry into the WTO, and it actually dated all the way back to 1986 when China tried to rejoin the GATT. The Republic of China, the government that now rules in Taiwan, having joined GATT at the beginning, but then opting out once it lost the Civil War in China. In fact, I have a friend who's a very prominent senior trade law expert in China who tells the story of her city government, Shanghai, coming to her on the eve of WTO entry and said, "We need to make all of our laws conform. Can you guys please go do that?" And her reaction, of course, was to laugh because it meant combing through literally thousands of pages of regs to make sure that China would exercise its sovereignty in ways that would bring the rules into line. Now, this, of course, is part of China joining WTO and broader liberal international legal order over this period. And the idea, of course, is a liberal project to make borders matter less, that is, reduce tariffs, non-tariff barriers, reduce conditions on investment, harmonize intellectual property laws, spread into trade and services, and perhaps regulation more broadly. So a huge amount here that meant relaxing traditional notions of getting to make your choices as a sovereign day to day, week to week, month to month. Of course, what I've just given is a very simplified sketch. China's commitment to this agenda was hardly unambivalent, and it was hardly completely implemented. And there was a political dimension here too. As I said, this was the heyday of US constructive engagement policy, and that came in two forms. The weak form of constructive engagement said if you bring China into this structure, into the international economy for trading and get it to bring its laws into line with GATT and then the WTO and to make the concomitant domestic changes, then China will have a stake in the status quo international legal order and the international order more generally. It will be a stakeholder supportive of the existing system. It will be basically a good international citizen. The stronger form of that argument was that engagement and integration economically, internationally, means domestic economic change, and in turn means domestic political change. It will become a more liberal place, perhaps even a democracy. That was a big overreach. I don't know how many people ever believed it, but for US domestic political purposes, to get into today's turf a little bit here, that was how it was sold. To sell Congress on taking the risks of opening US markets more fully to China, the argument was this would make China a more benevolent polity at home. The problem, of course, is it hasn't quite worked out that way on pretty much any front. So I'm going to do part two here, which is the news story. How and why we see a loss of faith in and support for the liberal project that I've been describing up to this point. And I'll focus on, as a big story, I'll focus on parts that at least have some connection to the sovereignty question. So first, the US began to complain quite bitterly that China does not play by the international legal rules of the WTO or by the specific specific commitments that China made as part of its accession, its protocol of accession, and that China in effect uses its sovereign power at home in ways that flout and violate its international legal obligations. There's a long and familiar list of US complaints here: market access for products and services, non-tariff barriers, slow walking approval of US importers and US investment, state subsidies to enterprises both directly and through state-owned banks, currency manipulation, although that's mostly an issue of the past, but it is a WTO issue, intellectual property rights violations, whether they are the failure to stop piracy, the tolerance or promotion of coerced transfers, or outright theft of sensitive intellectual property. Second, there's a more subtle and interesting complaint that the rules of the WTO don't do a very good job of getting at the things that China does that are problems, especially from the US perspective. So how do you really police somewhat lax enforcement of good laws on the books? That's been a big issue in the intellectual property space. How do you deal sort of slow approvals or uneven enforcement of quality standards or labor and environment standards, and so on? How do you police lax environmental and human rights standards at home that make exports cheap? In principle, some of these can be reached by some WTO norms, but it's not easy, and in some cases it's not possible even in principle. Enterprises in China are not purely, or in many cases much at all, profit-oriented or market disciplined. There are de facto soft budget constraints, bank lending that's done on policy grounds by banks that themselves don't face hard budget constraints, don't have to make market-based loans. State influence is exercised in a lot of ways that aren't the kinds of laws and regulations the WTO polices, but they're more subtle things like the state, SASAC as it's known, the state asset owner, is basically the way the state owns a lot of corporatized but still state-dominated enterprises, and the state as owner has not terribly traditional shareholder agendas, so it can have enterprises play by something other than the market rules the WTO system assumes. There are pressures and incentives on Chinese companies to look out not just for their own interests, but for the interests of their larger corporate group or even the national economy. The Chinese Communist Party has a role in picking the managers of major state-owned enterprises and placing members on the board. People in these kinds of enterprises across the board in China know how to read the policy winds. Even private enterprises are often deeply entwined with state-owned enterprises or get economic opportunities through political ties to the state. And now, under recent reforms, the Chinese Communist Party has cells even in, or supposed to have cells even in private enterprises, and they're just sort of informal coordination. There's a residual plan in some sectors, and then there are other issues which exist in almost all economies, but are a little more prominent in the Chinese case. There are state regulations that can be quite informal and hard to track. There are domestic standards being set, sometimes consciously, technical standards and safety standards that are set sometimes consciously to take advantage of China's large market to shape international standards in ways that give its companies advantages. Third, China, on one line of argument here, and the U.S. critique, is trying to now change the rules of international trade and international economic law. So we talked, the Clinton era pitch of get China in the WTO was that China will be socialized into things that we rather like. By the time you get to the Obama era, and we're talking about the TPP versus the RCEP, it's phrased as a contest over who will write the rules of the international economy. A liberal, more expansive and opening U.S. approach, or a more statist, tolerating Chinese one. And China self-consciously is trying to shape the rules. Indeed, we just saw this a day or so ago in Alaska, when the U.S. position is to say, we are defending the rules-based international order against subversive challenges from China. That covers a wide range of issues, but it certainly includes the international economy. And the U.S. is increasingly charging China with varying degrees of credibility, and critics who are not the U.S. government are also making the same kinds of charges, that China is coercing other states economically and is perhaps trying to reshape their internal orders in ways that are to China's liking on the economy, trade, and other issues. So the last thing I'll say here is sort of a few words on the crisis of this liberal trade arrangement in the U.S. and China that has come unstuck. The problems start before Donald Trump. They certainly accelerated during Trump's presidency. Some of this is a straightforward frustration on the U.S. side with the WTO system that doesn't seem to work very well for dealing with the China problem, as I noted. But there's Chinese frustration as well, the sense that they're constantly being blamed for violating rules that they don't think are appropriately applied or fairly applied to China. But underlying that, with this I'll close, three bigger picture concerns. One is global economic changes. China became so big that all of its behavior was hugely consequential and thus became a political focus, a policy issue for the US in a way it wasn't when China was smaller. Secondly, globalization has had a big income and jobs impact on some sectors of the US economy, the redistributive aspect here, and that was heavily blamed on China, even though it's really more of a globalization problem. And thirdly, under global economic changes, most importantly, the problem is China moved into economically advanced and dynamic sectors, cutting-edge sectors that the U.S. cares a great deal about and that were the targets of Chinese industrial policy to promote the 10 strategic industries and so on. A third major theme here in the way things changed, the way we came to our current impasse, is that economic issues have been securitized. They've been turned into national security questions. So we worry about Chinese acquisition through trade, partly of dual use or sensitive technology. So we see the export controls kicking in. There's worries about Chinese technology as a form of infiltration through exports, whether it's backdoors or trapdoors built into Huawei broadband hardware or cell phones that might be used by government officials, or even in some of the more fever dream versions that DC metro cars, if made in China, would provide ways of listening in on federal workers commuting around the greater Washington area. That Zoom is routed through China. That user information will be taken from TikTok and WeChat. Those last examples start to get back into the realm of the more plausible. And relatedly, more broadly, the concern about the vulnerability of supply chain disruption. That is that China's role in exporting much of what we need, whether it's ventilators and masks or something else, that could be disrupted for political reasons or perhaps due to natural disasters. So this heavy politicization of trade. And finally, there's the bigger politics that feed into this. The constructive engagement approach didn't fully work. China did not become a responsible stakeholder in Bob Zoellick's sense, much less a like-minded state on economic issues. And from the Chinese side, there's pushback as well. This is a two-sided story. China started to see a lot of what the US was pushing as peaceful evolution. That's a transitive verb in China. It's an attempt to peacefully evolve China into something we like better. And that started to resonate with criticisms of 19th century encroachments on Chinese sovereignty when the early encounter with the West included quite specific demands that China change its international trade laws to grant the West freer access than China was willing to grant. But I think what's underlying a lot of this is this underlying shift in international power. The US is no longer the dominant hegemon. It can't reap a disproportionate share of the benefits of an open trading system, so it's less willing to pay for their provision through underwriting, to allowing cheating or underwriting the costs of the system. And it worries about being vulnerable to asymmetrical interdependence, the sort of Albert Hirschman problem that China can use economic levers to hurt the US, and the US can do the same to China. And there's a concern that China is now starting to put together its own model of the way one should organize one's domestic economy and one's trade relations. So it's taken on something of an ideational rivalry, which we see in many spheres, but trade is certainly not missing from it. I think I've probably run over my time, so I'll stop there.
Well, thank you, Professor deLisle. And we've got people chomping at the bit to ask questions. So let me just remind our viewers here this afternoon, if you have a question and you're watching us on Zoom, go into the chat function, type out your question, and we're going to get to it shortly. But before we get to that list, I want to give our panelists an opportunity to respond to some of the points their fellow panelists made. And I want to begin with the gauntlet having been thrown down wonderfully by Jide, who primary point, I believe, that the current moment in trade, as it were, isn't really centered on trade. It's centered on issues of identity and other things which go to people's personal core of understanding who they are and what they believe. And I wanted to put that to two of our panelists who have been deeply involved in the past in making trade policy. Ron Cass, who served on the International Trade Commission, as well as Gary Horlick, who served as trade counsel to the Senate Finance Committee and also worked for the Department of Commerce making trade policy. How do you respond to what Jide had to say? Does transparency hurt what you did there? Are the people who are unhappy with trade policy one way or another? Is trade really what they're angry about when they call you up at the Department of Commerce, or was it really something else?
Well, I'm happy to take a crack at that. I think one thing that has changed over time, of course, is that what tariffs used to provide to the U.S. was the lion's share of what was going to fund the U.S. government. Prior to the early 1900s, when we had the 16th Amendment, which gave us the graduated income tax, we used to have tariffs as the primary form of funding things. So a lot of people liked tariffs if they needed anything from government. But by and large, people divided over tariffs back in the early 1800s based on whether the region they lived in was a region that was going to benefit more from having tariffs on goods that came in that competed with the products they produced, or whether they would be hurt by it because they would have to pay more for everything they needed. a lot of people don't always do what you would think they would do based on their individual self-interest, but there was a large overlap of where you lived and what you believed on tariffs. I think part of what Jide was talking about is a more general problem in a large country with lots of voters and very little likelihood that anyone's vote is going to be outcome determinative in any serious election. A lot of people bond with other folks that they see as having similar interests generally. And it's not necessarily identity politics in the ordinary sense that we see it today. It's more identifying with a class of people, with a region of people. And so you see a lot of people who were angry about globalization because it was more competition for what they did. It reduced their income. It left the businesses in their town more vulnerable. A lot of those businesses would pick up roots and go elsewhere and hurt not only the people working for them, but others in the town. A lot of what happens when you raise the profile of trade debates is that you get more heat on those issues. When the heat goes down and the visibility of trade issues go down, you end up still having people deeply invested in it who are going to argue about what trade policy should be, and very largely are doing it on the basis of their own self-interest, which doesn't put aside the fact that there are serious differences on what's in the nation's interest. Let me stop that. I do want to come back to one question about China later on, but let me pass the ball at this point to Gary.
Thanks very much, Ron. And I note that they couldn't call Ron. We're not allowed to call commissioners, but they sure called me, both at Senate Finance and the Commerce Department. If you look back, I agree with Ron. First of all, the U.S. started as a very free trading country, probably the most free trading in the world at the time. Why? Because the British hadn't let us do that. And the U.S. founding documents, the Constitution, the Second Act of Congress passed a very low tariff to raise revenue, as Ron just implied. And again, the Fourth Amendment search warrants, that's from British customs agents breaking into John Hancock's warehouse without a warrant, et cetera, et cetera, et cetera. So anything the British had done, we rejected. And that changed after War of 1812 because now there was an industry that had built up during the war, textiles in New England. And from then on, the history of trade policy in the US is overwhelmingly special interest lobbying. And if they can demagogue it, great. And that's what's been happening ever since. The last 4 years were extreme. The 232 tariffs Judge Vaden referred to, and by way of disclosure, I started the case that got to his court, though unfortunately perhaps not him, to challenge those. And but the Secretary of Commerce doing this had owned a steel company in the U.S., was on the board of the biggest U.S. producer until he became secretary. And the U.S. Trade Representative had been an advocate for the U.S. steel producers for 35 years. In Washington terms, that's a trifecta. You don't usually get that. But some of this gets you into China. So what if you take apart the negotiation of China's accession, which was when we had peak bargaining power with China. China wanted in. It wasn't going to open our market because we already had a bilateral agreement with China. And we fought to the death to keep in place two things: 6 years of extended quotas on clothing. Our U.S. clothing production is like 2% of U.S. consumption. The industry's gone. For whatever reason, it's gone. Some of the workers are badly off. Some of them in the South are now making BMWs and Mercedes at 3 times the income. So I'll let someone else argue if they're better off or not. And the other thing we defended was our right to apply outrageous manipulations of the dumping law to China. So that's what we spent our bargaining chips on. We didn't spend it on things like government procurement. That's the big one we didn't get. China did not liberalize government procurement, and the government is half the economy in China, as you heard. So we traded off something worthless, basically, in return for something really important. Why? Because of special interest lobbying. And as long as we have an open democratic system, which thank God we do, that's going to happen in trade as well. So what it takes now, and this laps into China again, is really getting bargaining leverage back. That's why if you don't join TPP, you do something in Asia that gets you relationships with other countries such that China wants to have access to that, and the same in dealing with the European continent. You have to do those two. It's not a partisan issue. The Republican Congress would have happily passed TPP, they said so, after the 2016 election in a lame duck session. And then Obama would have signed it.
All right, thank you, Gary. I'm going to ask one more question before we go into our list of questions that are being submitted. So please keep submitting them. But Jide, you noted the passion that has surrounded trade in recent years, and you've linked it with deeper meanings, unrelated to trade in some ways, that the supporters pro and con have. Professor deLisle, in his comments, noted that some years ago, those who were advocating one type of policy toward China promised certain things might result, an opening up of China to democratic ideals and other such things. And as Professor deLisle noted, that hasn't exactly come to pass. Do you think that some of the passion that we're seeing around trade right now has to do with the fact that, as the title of our panel notes, when you're dealing with trade, you're dealing with issues of national sovereignty. And when it comes to the United States, you're dealing with the relative power of the United States and the world at any particular point in time. And are these passions that you're seeing related to coming competition with China, or do you think they're disconnected with that and would have spurred up anyhow? You're on mute there, so you may want to unmute.
Okay, I'm unmuted now. Can you hear me? Yes. So I would say they may be connected, but I would say even the connection is a little bit, if I want to call it, has a fault line identity politics element to it. So what happens is that, let me give you an illustration, and there's some ironies in what I'm about to say. So typically, when the issue with China started revving up, economists, and you see a lot of these things in the Wall Street Journal and everything, would say trade war is coming, right? And then they try to illustrate what the economic implications of a trade war will be, right? You understand what I'm saying? But they want to highlight and warn the public of the risk of a trade war if we keep up this rhetoric. And in one of those articles, right, Trump, by the way, President Trump, who I think was smarter politically than the economists on this issue, said, yeah, there is a war coming and we're going to win. And that, I think, is he caught them off guard, which is the following. If you're a trade economist and you're worried with what was going to happen with China, you kind of wanted to bring down the stakes, lower the stakes. When you increase the stakes, right, and you use this language of war, what people think is going to happen is that the population are going to hear it and they're going to say, oh, this is terrible. I'm going to have to pay more for my television. This is a bad idea. But if people hear the word war, they're probably going to think, well, if there's a war, we want to win. What they want you to do is to beat the Chinese, just however, make them cry and pull out. And so what happens is that I think that was just a rhetorical mistake, right? Because I think it raised the salience, right, of this issue, and probably made a lot of people think we want exhibits that show that we're beating them. Ironically, the Chinese responded by trying to lower the temperature. And part of the reasons why I think they were doing is that they were being smart too, because if they make any concessions, right, to the Trump administration, they want to say, well, we made these concessions because they weren't that important to us, right? And partly because they lowered the temperature. Had they increased the temperature the same way we did, there's a risk that then they would be locked in an identity politics spinoff. And then, they would have to also do something. This is where, say, the volatility comes in. But I agree with you that there may be some aspect of the sovereignty, especially with Chinese politics, that can make this salient. But I do think, and this happened with Japan under the Reagan administration, there are backroom conversations that can often take place outside the limelight, where people make quid pro quos, right, and make resolutions, usually what I would call bargaining in secret, right, and then come in and say concessions were made and they move on. But what I'm trying to say is that if you now make this a purely public fight that is transparent, you've now raised the stakes. The audience wants to see, I want to make sure you don't back out. If you back out, it will be shameful to us. So I want you to make them, pin them down and make them cry. That's what's going to happen. And I just think part of my frustration is that a lot of the rhetoric by a lot of people writing newspaper articles, really smart people, is that they raised the stakes because they kept on talking about trade war, all assuming that when the public believes there's a trade war, that the first instinct is let us withdraw so that we don't pay higher prices. And I don't think that's what's likely to happen. So I agree with you that there is an element that of the sovereignty thing. I agree with you that there were probably backroom deals that could have been made and much more inauspicious ways. But I do think we missed a lot of opportunities when it became too silly.
Well, thank you, sir. We've got some questioners who've got questions for our panel, and I want to get to them. So we'll go to the chat, and we'll start off with one. I'm going to initially direct this to Professor deLisle, but please, after Professor deLisle gives his answer, any other panelist that wants to chime in, do so. Professor deLisle, our questioner wants to know, do you think a trade war with China is inevitable given the communist nature of the regime and the desire of China's current President Xi, to basically serve as a dictator for life, according to our questioner? Is this the essential real cause of the trade developments with China, or do you see something else at play?
I think there are a few pieces at play here. I mean, some of it is just the nature of the economic relationship we've got, which is as China has become a larger economy and a more advanced economy, it is competing with the US in spaces that we care about. Not the 2% textile workers who may get some leverage in domestic politics, but stuff that really does matter. As well, so you get the whole range of workers in declining sectors to high-end intellectual property intensive industries that are worried about China eroding their advantage, whether it's through industrial espionage or industrial policy in China. So there's a genuine set of economic competitive elements that are there. They get exaggerated, I think, in U.S. politics for reasons that my colleagues on this panel have discussed. It's an unfortunate fact of trade accounting that the U.S.-China bilateral trade deficit looked huge, and therefore politically in the U.S. could be framed as China is running this huge surplus with us, when in fact, of course, it's a global thing. It's just that a lot of the products got on the boat in China after having a lot of value added elsewhere in the global supply chain. So I think in that sense, there are two things going on. One is the genuine economic transformation, another is the US politics of this, and then there is the Chinese politics of this. And some of that is that China is feeling its oats as a more potent state, and it's at least as much nationalist as it is communist these days, and it wants to essentially have some of the same kind of role the US used to have in leading international rules, and now positioning itself as the principal supporter of a certain type of globalization. We're starting to see the U.S. push back on that again. The difference between political system types matters, I think, in two ways. One is there is a connection between the state capitalist, if you want to call it that, or at least not market norm fully conforming economic structure in China, those kinds of things the US complains about that the WTO doesn't give great tools for dealing with. There's a connection between that economic structure and the political structure. And we do have a sort of big picture ideational rivalry. You saw it very much on display in the quite contentious statements in Anchorage. So I think it tends to sort of spill over. When you've got a generally bad relationship and there's a sense of a contest between two models, that tends to be a multi-sectoral, economics, politics, everything. And once that happens, I think you tend to get a lot more confrontation and a lot more sense that there is a rivalry going on. So there is, to use the metaphor that Jide was referring to, a war. And once you do that, well, trade wars are part of wars.
If I could jump in on this as well, certainly I think it is undeniable that in any trade issue, whether it is about China or anything else, there are people who will exaggerate the problems. They'll exaggerate the threat. There are self-interested reasons for that. There are ideological reasons for that. But there are also people who have self-interested and ideological reasons to downplay threats as well. And to the extent, if you have a nation that does want to use trade and economics to its advantage and to use trade and economics in some respect to enhance conflict with other countries, or potential conflict, or potential supremacy with respect to some aspect of other countries, we really need to look at that side of the balance as well. And for those of us who are instinctive free traders, it's usually the first instinct is to say, well, that's an exaggerated problem. I know when people were worried back in the 80s about Japan, and the Japanese were coming over and buying a lot of iconic American properties like Rockefeller Center, there were complaints about that. And I never quite understood that, because at that point, we had the money from the Japanese who bought Rockefeller Center, and we had Rockefeller Center. They weren't, it wasn't on the plane back to Japan. So I never quite understood the problem there. But I do think I have a lot of friends who study China, a lot of friends who do business with China. And a theme that runs through it is that there is an image of where China wants to be, where the Chinese leadership wants to be, vis-a-vis the rest of the world. And that a lot of the way the government works in China on the ground is in line with that. The only metaphor I have is when I was a law school dean or a law school professor, we used to have a student faculty basketball game. And the students had a few advantages. There were more of them. They were younger. They were more athletic. They were better basketball players. They didn't get out of breath as quickly. The faculty had one thing in its advantage. We had the referee, who was a faculty member, who, no matter what the rules were, would turn the rules to the advantage of the faculty. He would call fouls that maybe no one quite saw. He would indicate that when a ball went out of bounds, clearly the reason was that the students had pushed it out of bounds, even if it was two faculty members fighting over it. And I think that there is a sense that in a lot of the administration of the law in China, you have something of that flavor. At least that is the perception that a lot of Americans are voicing. So I think we do have to take seriously some of the potential problems, even if we have reasons to suspect people will overstate.
Well, I want to get to the next question, if that's okay.
Go ahead.
And Gary, I'm directing it to you, so hold your thought. This is a question from Harrison Shore, and it kind of goes back to first principles when it comes to trade. So I think it's appropriate for you, but others can chime in after you give your thoughts. Harrison wants to know, do you think that the traditional economic model in which nations benefit from each other's comparative advantages actually matches what we see in reality? How should we think about trade with countries that heavily subsidize certain industries?
Okay, let me start at the back and go forward. The countries which subsidize the most, as far as anyone can tell, and it's hardly transparent, but I've spent a fair amount of my time investigating subsidies in detail. The two big subsidizers are China and the United States. We happen to do a very poor job of it because what we do is state and local subsidizes in a bigger than neighbor competition for plant locations, which is the subsidies don't benefit the country. They benefit bottom lines of companies. I've participated in some of these. It doesn't lead to anything. If there were no subsidies involved, people would still be building those plants in the US. So it's just a waste. But there's huge amounts of money involved. China also has a lot of subsidies. And it's actually bizarrely enough, if you hire people who can read Mandarin, it may be easier to find the Chinese ones than the US ones. I can go into more detail if anyone wants to. It's not easy in either case. So, but overall, I do think, I'm not an economist, comparative advantage does work. And lots of economists, you don't get a PhD by saying comparative advantage works. But the fact is it does work. You get your PhD by finding some obscure exception. There was a whole bunch of this in the 80s. I won't name names because they're all famous now, who would then go on to say, but that exception will never occur in real life, and it doesn't. So I think the claim that, comparative advantage doesn't work, et cetera, usually that's not coming from independent economists, it's coming from special interests with their particular example. That's A. B, having been an American trade official, I'm very worried of getting too hyped up about subsidies because we're vulnerable. The same, by the way, is true of state-owned enterprises. The U.S. has owned state-owned enterprises. We've gotten rid of the biggest auto company, the second biggest bank. I think we still own the biggest insurance company. We own the biggest mortgage lenders. We own the 6 largest electrical generators. There are 1,000 municipal electric companies. We have a fair amount of this stuff. So again, it's easy. I see all this stuff. Oh, we got to do this. We need a rule against that. A rule against that. My answer is always fine, but make sure we're exempt. That's a practical answer. More seriously, what you get into, and I'll turn to China again. I'm not here to defend China, by the way. I have won cases against them in the WTO. China's compliance record in the WTO when it loses cases is not worse than ours. These are big countries like to do these sorts of games. Having said that, and Professor deLisle touched on this, I see 2 X factors here. One, China is the largest consumer market in the world. What they're teaching at Wharton Business School is you better be successful in China or you're going to lose out globally. If you're not selling mobile phones in China, and Samsung is, and they're going to have better economies of scope, scale, et cetera, their cost per phone is going to be, unit cost going to be lower in the US than yours. And you're going to lose in the US. That's a simplified version, but that's what they're teaching. So bear that in mind. Secondly is the role of the Chinese Communist Party, or any centrally run political system like that, not picking on China. Having said that, we signed a trade agreement with Vietnam, TPP, and now want one without TPP with Vietnam because it's a growing market. And the Vietnamese, the Communist Party of Vietnam, I think that's what it's called. The Communist Party of Vietnam pretty much runs a lot of things also. So this is not the first time we've had to deal with fairly centrally controlled economies. You sit down and you negotiate and you find ways to do it. And yes, visibly there was a sea change, sorry, bad pun. There was a sea change. When President Xi took over, there's clearly a change. A lot of the stuff about how we thought China was become democratic and we opened our markets, that was salesmanship. No one really believed that. The Communist Party had shown no signs of going away. And in fact, by making the place more prosperous, we were cementing China's claim to, the Communist Party's claim to success because there was something in it for us. Our companies do very well in China, and that contributes to their health here. So it's a semi-balanced view, but it's certainly based on what goes on. So what we need, my bottom line is we need a lot more bargaining leverage with China. And that number's gone up. So basically we need to make a common front with the EU and other European countries. So that includes Switzerland, Norway, Ukraine, probably Turkey. We need a common front with Asia, which would have been TPP, but all in addition to TPP, you need Korea, you need Indonesia, you need that. You have to assemble your allies. And that now I'm not talking comparative advantage, so I will defer to the political scientists among us.
Well, thank you, Gary. We've got about 5 minutes left, and I want to get one last question in, and I'm going to direct that question to Jide. Jide, you've heard what Gary had to say in his response about comparative advantages, and though some people may not have seen it as salesmanship, there's some people who feel kind of sold a bill of goods with regard to what they were told about what free trade could do earlier. So I'm curious as to your reaction to Gary's response to the question on comparative advantages and how these trade agreements were sold. But as part of that, I'd like for you to share with everyone the chat discussion you had regarding a question that Sophia asked you, and that's kind of tied into this. She asked you, is there a way to transcend identity politics and focus on the economics without increasing the level of transparency? What would removing identity politics from the current political sphere mean for, I assume she means the trade policy future of the Republican Party?
I do think that that's possible, just on the latter point, and I maybe just say this very quickly. I actually do think that one of the geniuses of Franklin Delano Roosevelt is that while prior to his administration, the tariff issue had been extremely divisive along party lines. One of the geniuses, and by the way, his own Secretary of State didn't quite recognize this, is that he decided, partly very, very providentially and thoughtfully, by the way, to say, I'm not going to pose as the free trade president. What I'm going to do, is depoliticize this tariff thing at the level it is by making sure protectionists get something and export groups to get something. And if I do that, nobody's going to think that the South is in my pocket, right? And he was able to do that. And that kind of lowered the temperature a little bit, because a lot of groups left the table in the 1930s saying, he got something for us, he got something for us. And I just want to say something, and this goes to what Gary said. I agree with a lot of Gary says about the value of comparative advantage and whatnot. The one pushback I have is how people depict interest groups. If you have a long horizon as an interest group, and by the way, this was true with a lot of Republican industrialists in the 19th century, one of the things that you don't like is volatility. And one of the ways you can get, because one of the things about volatility is that somebody can give you something now, like you win something now, but you know that once the next cycle comes in, your opponent is going to win and take it away from you. Many of these industries, and this is true with labor groups and whatnot, want a deal that is going to last.
Yeah.
And if that deal, if you can give them a deal that will last multiple electoral cycles, including the protectionists, they're happy. What they don't want is every time an administration swings, they have to replan their entire economic model.
Good point.
And I do think we have missed this part of what the interest groups bring to the table, which is that they bargain for stability. Identity politics people don't care for stability. Right? They would, even if it wrecks the economy, even if there's instability, they would prefer that the identity be recognized. And one of the things I think we ought to go back to is a situation where you take these interest groups in, take the labor group, AFL-CIO, lock them in and say, you're going to be dealing with these people, with these steel industries the management for the next 6-7 electoral cycles. Make a deal that will last. Don't be parochial and do it behind closed doors, and we will defend it. If you do that, and it's behind closed doors, then they're going to be more willing to lower the temperature when they come out, because they'll be saying we got something out of it. And if you notice the USMCA, the labor groups did lower the temperature because they were not sidelined. Under NAFTA, they were kicked around, and that made them hot-headed, and it made them politicize it more because they felt they had no choice. So this is my view. My view is take a transactional approach. I agree with Gary completely. I'm just saying the politics of it should push us to think of it in a more transactional, low stakes way, make all these groups happy. Because if you don't make them happy and if you sideline them, they may feel their only option is to go public. And going public is not good for anybody. That's my take.
Well, thank you, Professor. And we've unfortunately come to the end of our time. So I'd like to thank Ron, Jide, Jacques, and Gary for the insights that they've shared. Hopefully this has spurred some future trade lawyers an interest in trade. And if you are interested in trade, consider a clerkship with me on the Court of International Trade. Yes. Now I'm going to turn it over to Eric, who has an important announcement as a part of the Federalist Society's wonderful Article 1 initiative.
Thank you, Judge. And thank you once again to all the panelists. That was a fascinating conversation. I was very lucky to hear it. I'd like to now introduce Nate Kaczmarek, who will be presenting this year's Article 1 award. Thank you.
Good evening. My thanks to Peter Redpath and the student division, as well as Eric and the Penn chapter for having me. As Eric mentioned, my name is Nate Kaczmarek. I am Vice President and Director of the Federalist Society's Article 1 Initiative and the Regulatory Transparency Project. Each year at the symposium, Peter carves out a little time right before the cocktail hour for Article 1 to announce the winners of our annual writing contest. I was hoping that this year's virtual forum would, for once, allow me to give the results without everyone in the audience wishing they were already mixing with friends and enjoying refreshments. Alas, our great Penn hosts have come up with a wonderful virtual happy hour to follow this announcement, and I am once again the one thing between you and the cocktail hour. I will therefore move quickly with the contest results and a brief announcement from RTP. As you know, Article 1 is focused on driving a nationwide conversation about our first branch. In addition to the videos, papers, podcasts, and events that many of your chapters have hosted, this year we were proud to sponsor our 4th annual writing contest to focus younger students, academics, and lawyers to the problems of Congress in order that they might wrestle with how modern innovation and constitutional restoration may occur. This year's theme was judicial interpretation and the erosion of legislative power. We received a wide range of essays to address this important topic from across the United States and Canada. Thank you to all of you who participated. This year's winners were selected by an all-star 3-judge panel consisting of Professor Lillian Bevere, Ambassador Boyden Gray, and the Honorable Chris DeMuth. The judges reviewed each entry without knowledge of who submitted it. Our 3 prize-winning essays impressively answered the call of our question, and each one is distinctive and interesting in their own right. The winners announced tonight will each receive substantial cash prizes. For 3rd place, we have $1,000. For 2nd place, there's a $2,000 prize. And for 1st place, we have a $7,000 check. And this year's winning essay will be published in the coming weeks in the Federalist Society Review. And now for the results. Our 3rd place winner was Alex McDonald, whose essay was titled Contextual Textualism: How Legislative History Can Restrain Judges, Revitalize Congress, and Restore the Conservative Legal Movement. Alex is an employment counsel at Instacart. He previously practiced employment and labor law in the Washington, D.C. offices of Littler Mendelson. He is a 2012 grad of William and Mary School of Law. Our congrats to Alex. At 20 years old, our 2nd place winner is the youngest writer to get an award from our contest. He's also our first Canadian author to receive an award. Adrian Alou's essay was titled First Among Equals: Reworking the Relationship Between Congress and the Supreme Court. Adrian is a 3rd-year urban planning student at the University of Waterloo. He has a broad interest in questions of law and public policy, with a particular focus on democratic and constitutional reform. Congratulations, Adrian. And now for our winner. The winning entry was Negative Legislation by Roberto Borgert. Roberto is a 2018 graduate of the University of Chicago Law School. He currently clerks for Judge Timothy J. Kelly of the U.S. District Court for the District of Columbia, and previously clerked for Chief Judge Jeffrey R. Howard of the U.S. Court of Appeals for the First Circuit. This fall, he'll be joining the Washington, D.C. office of Latham and Watkins LLP as an associate. While our elite judges are a critical and exacting bunch, I glean these quick reflections from their notes on Roberto's essay. Quote, this thorough and well-written paper importantly took up the Article 1 Initiative's assignment, which was to actually propose ways that Congress might show greater institutional ambition in the face of judicial usurpation and claw back its legislative prerogative. It was in-depth and with earnest, impressive consideration of pros and cons. As compared to the rest of the pack, Roberto's essay, quote, presented the most interesting and creative solutions of the contest. Congratulations, Roberto, on a job well done. We all look forward to seeing your essay published in the Federalist Society Review. Thanks again to everyone who participated. If you'd like to compete in next year's Article 1 contest, stay tuned. We'll be announcing the contest theme in August. One more quick announcement from me. As I mentioned, my other project with the Society is the Regulatory Transparency Project, or RTP. As you know, our first feature-length documentary, They Say It Can't Be Done, is available for pre-order on iTunes. And just a quick plug, this week only, today through Sunday, there's a flash sale and you can pre-order it for $6.99. So please jump on your iTunes or Apple TV account this weekend and snap it up for this low price if you're interested in watching it soon. If you don't want to search around for an iTunes link, here's an easy one to remember: fedsoc.org/documentary. With that, I thank you all for your time this evening, and I hope you enjoy the rest of the symposium. I'll turn it back to you, Eric, for all the details on the virtual cocktail hour. Cheers.
Thank you, Nate. So we're about to move into the virtual cocktail hour, which will be taking place on Topia. Everyone who's registered for that event should have received their login information. That would be the password that you should have received in a link. This is for active dues-paying members of the Federalist Society and for students particularly. And to the rest of our audience, to the ones who will not be attending this reception, I wish you a very pleasant evening and I invite you to join us for panel 3 at 1 o'clock Eastern time tomorrow. Thank you.